Again, speakers have performed their job well. Now I will express my privilege to convey you the benefits of codified parliamentary privileges. Good morning, everyone. My topic is codification of parliamentary privileges, expected certainty. Parliament and my mother has one thing in common. To question them is a dangerous game. The parliamentary privileges is an integral part of every parliamentary democracy, and even in the case of a nation which has the presidential type of democracy, the words for any speech or debate in either house, they shall not be questioned in any other place, have been given the same immunity as in the parliamentary democracies. More than 70 years of the freedom have passed after independence, but Indian Parliament is unable to legislate and lay down the Code of Privileges. Clause 3 of Article 105 of the Constitution of India clearly envisages a legislation on privileges, but it has not so far been undertaken in view of some practical considerations. This is rather strange and unwelcome. Article 105, Clause 3, as amended by 44th Amendment in 1978, provides that in other respects, the powers, privileges, and the immunities of each House of Parliament and of the members and the committees of each House shall be such as may from time to time be defined by Parliament by law, and until so defined shall be those of that House and of its members and committees immediately before the coming into force of Section 15 of the Constitution 44th Amendment Act. Now, having specifically incorporated the most fundamental parliamentary privileges and most basic immunity in the text of the Constitution, the Constituent Assembly decided to leave the powers, privileges and immunities of each House of Parliament and state legislatures to be defined by law by the Parliament from time to time. In the Constituent Assembly, Dr. Rajendra Prasad had said, the Parliament will define the powers. The Parliament will define the powers and privileges, but until the Parliament has undertaken the legislation and passed it, the privileges and powers of the House of Commons will apply, so it is a temporary affair. The substance of conferring this privileges collectively on the legislative bodies and individually on the members was to enable them to act and discharge their functions effectively, without any interference or obstruction from any quarter. Through these privileges, the Member of Parliament have been given somewhat wider personal liberty and freedom of speech than an ordinary citizen, so that it may vindicate its authority, prestige and power, and protect its members from any obstruction in the performance of these parliamentary duties. The privilege of the House has two aspects, internal and external. The external aspect is that they refrain anybody from outside the House to interfere with its working, and the internal aspect is it also restrains the members of the House from doing something which may amount to an abuse of their position. The Indian Parliament is the creature of a written constitution, which implies that Parliament has to work within the limitations imposed on it by the written document, as this document is the fundamental law of the country. The legislative power of the Indian Parliament is subject to the constitutional provisions, and the Parliament has no power to legislate beyond the assigned subjects. Parliament and state legislatures are prohibited from enacting any law inconsistent with the fundamental rights provided by Part 3 of the Constitution. In a vibrant democracy like India, where the Constitution and not Parliament is sovereign, the parliamentary privileges should be codified for its clear interpretation. The legislature must use the power to punish for contempt or breach of privilege sparingly, invoking it mainly to protect the independence of the House and not to take away the liberty of the critics. The National Commission to Review the Constitution said in 2003 that the only idea behind parliamentary privilege is that members who represent the people are not in any way obstructed in the discharge of their parliamentary duties and are able to express their views freely and fearlessly inside the houses and committees of Parliament without incurring any legal action on that account. Privileges of the members are intended to facilitate them in doing their work to advance the interest of the people. They are not meant to be privileges against the people or against the freedom of the press the Commission recommends that the time has come to define and delimit privileges deemed to be necessary for the free and independent functioning of Parliament. But the Parliament is like, खेल भी हमारा, शर्तें भी हमारी, खेल भी हमारा, शर्तें भी हमारी, हमारा नुकसान गर्दन तुम्हारी. Let the game be dangerous, but knowledge of rules is the right which all the players must be entitled to. In India, the demand for codification is not new. Since early 1950s, concerns have been raised, especially by the press, to remove the alleged arbitrariness prevailing in the exercise of privileges by the legislative bodies. Even the judiciary, while deciding controversial matters relating to privileges, and its obiter dicta has observed. Justice Subbarao, in such like case, as has been mentioned by Pawan, has strongly pleaded for codification of privileges instead of keeping this branch of law in a nebulous state, with the result that a citizen would have to make a research into the unwritten law of privileges of the House of Commons at the risk of being called before the bar of the legislature. The learned author D.D. Basu, in his book on the commentary of the Constitution of India, advanced the following arguments in favor of codification. He said, as against this, it may be stated that the need of parliamentary privilege to maintain the dignity and independence of the nation's representative, acting as a legislative body, has to be reconciled and harmonized with the need for individuals' rights, which are equally essential for the development of the country. As individual liberty is one of the very objects for which national independence is fought for, the English system of giving unfettered freedom to the legislator in this respect is not fully applicable in India for two reasons. If the legislative privileges are codified, they will be consistent with fundamental rights. This will ensure that the legislators do not act in any arbitrary manner and remain within the confines of the limits imposed by the rule of law as embodied in our Constitution. Now the mothers devote themselves wholly to the family, as I've taken an example, but the insatiable desire of these politicians doesn't allow them to welcome honest criticism from any sphere outside their spheres. It is imperative to have an effective ethics regime in order to regulate the behavior and actions of the members of the parliament and legislative bodies to avoid the misuse of powers, privileges, immunities, rights, and the facilities enjoyed by them. The benefits of codification of parliament privileges are accessibility, intelligibility, simplicity, as well as its general convenience. Unrestricted speeches or the floors of house are no doubt valuable, provided they are not misused, lowering down the sanctity and dignity of the nation and of the house. The nation witnessing so many noisy sessions, shouting slogans, physical assault, walkout even when the crucial business is under consideration are not uncommon. Watching porn video clippings, throwing articles on each other, as what happened in UP Assembly in 2011, in October 1997, Karnataka Assemblies in 2011 are shameful incidences. But how long should the public at large have patience to tolerate this vandalism under the veil of privileges? A great number of these problems could be avoided if legislative privileges are codified. After all, the same has been done for legislative privileges in other countries such as South Africa, Australia, and our very neighbor Sri Lanka. And no remedy is in sight, nor will be, as long as Indian legislators refuse to accept the weight of opinion that enjoins them to define their privileges. The irony is that in doing so, they appear to ignore even the Constitution that they sworn to uphold. I'd like to end by a quote by Jeff Rosses, an eminent authority on Parliament. He asserts that it is not primarily professional skill or technical knowledge that are needed in the legislative branch of the government, but high quality of mind or heart and character. Thank you.